$10. $10. Why am I seeing $10 in the real estate contract? How do I explain that to my client or customer? Do I have to collect $10 from the buyer to give to the seller or the other way around? What is this $10 all about? Hi, everybody. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. Today's contract tip is all about the $10 consideration in a real estate contract that you see in the Georgia Association of Realtors contracts, the RE forms contracts, and many, many other real estate contracts, generally speaking. So what is it? What is that $10 all about? Well, that is in general a legal connotation. Consideration is required for a contract to be, that's one of the elements of enforceability for a contract for real property. Here in Georgia, could be in other states too. I'm not familiar with those, with the other states' laws and contract laws. Generally speaking, consideration is a legal term. It is something of value that is exchanged between the buyer and the seller, again, to make the contract legally binding and for enforceability. It is basically something so that each party has a stake in the game, has a stake in the agreement, and putting up something of value. So generally speaking, it can be money, it can be services, it can be goods, it could be what they promise to do. In a real estate contract, at least in the GAR and the RE forms contracts here in Georgia, the earnest money is not the consideration of the contract. So you do not need earnest money to make a real estate contract here in Georgia enforceable or binding or valid. That has nothing to do with the consideration. Generally speaking, the consideration really is the transfer of the title or the property between the parties. However, what you often see in our GAR and the RE forms contracts is it specifically says $10 consideration, the receipt and sufficiency of which is hereby acknowledged. What does that mean? That means that there is $10 is stated as the consideration for a particular agreement within the contract. And when you see the phrase, the receipt and sufficiency of which is hereby acknowledged, the receipt means the party receiving the $10 in consideration for what the other party is going to do. It's saying on paper they've received it. They do not actually receive it. There is no specific $10. There's no money that changes hands for the consideration. That's why it says the receipt is acknowledged, and the sufficiency means that is something of value enough for what it is that is being agreed upon. A lot of times it will say, and other the $10 and other valuable, the receipt and sufficiency of which is hereby acknowledged, and other valuable consideration. One of the other reasons that it might state $10, the receipt and sufficiency of which, in consideration, $10 consideration, the receipt and sufficiency of which is hereby acknowledged, would be to actually keep the actual sale price out of the record, out of the deed. So that's just another reason. And some examples that you might see I just pulled out a few examples from the GAR purchase and sale agreement, the Georgia Association of Realtors F201. It's throughout many, many forms, but just for example, under the inspection and due diligence paragraph, under paragraph A8, it talks about in the due diligence, it says, in consideration of the seller granting the buyer the option to terminate this agreement. So for that, the seller giving the buyer the option to terminate for any or no reason within that time frame, the contract goes on to say in consideration of the seller granting the buyer the option to terminate the agreement, the buyer has paid the seller $10 in non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. Again, that money doesn't change hands. That's why it has that other phrase. But that is the consideration for the exchange of the seller giving the buyer the option to terminate. Elsewhere in the GAR purchase and sale agreement, under paragraph B5F, under closing, it says the closing shall be the event in which the parties consummate this transaction set forth in the agreement by, number one, the seller tendering the deed referenced in the reference herein to the property. Number two, the buyer paying the required consideration here under. And then it goes on to the parties signing the documents and so forth. There's a whole lot more that actually constitutes a closing. There is another paragraph further on in the purchase and sale agreement where it talks about potential bad guys, fraudulent sellers, and there's an issue there where the parties agree not to sue the parties for if there is a fraudulent seller involved. And so what it says in paragraph C7, for and in consideration of $10 and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, buyer covenants not to sue any broker and or the closing attorney involved in this real estate transaction for damages arising out of or relating to a fraudulent seller. So again, those are just some examples. There are many more throughout many of the amendments and the exhibits, but I just wanted to explain that the $10 does not exchange hands. That's why that additional phrase is there. Nevertheless, consideration is one of the elements for enforceability for a contract for real property here in Georgia. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.